Okay, folks, we're going to go ahead and get started. Hello, everyone. Good afternoon. Daniel Silva, President and CEO of the KCK Chamber of Commerce. Excited to bring this presentation to you all today. Looks like I just saw someone pop in the waiting room. Happy to be here with you all. Also, I'm joined by Caitlin Kaminsky, our Director of Marketing, and Katie Vivas, our new Director of Membership. So happy to have the team here on the call as well. I want to communicate that these presentations are part of a broader goal for us to really hone in on very specific business needs from our small business owners and from our members. And so we have heard from our folks that they would like more opportunities to speak about these types of forums, these types of subjects. We also have a Doing Business With series. So we've hosted Doing Business with KCK Public Schools last month. In early June, we'll be doing a series on doing business with the BPU, doing business with the UG, and then doing business with, I forgot the other one. We have a series of events about doing business. So again, thank you for being here with us today. I want to give special thanks to our sponsors listed there at the bottom of the slide. These are the folks that are really supporting the work that we're doing in the small business arena. At this point, I would like to introduce Cecilia Brown with Newby and Associates, who will be leading us through a presentation on how to decrease liability in lawsuits of employment discrimination. That's a big old mouthful. I tend to get nervous when there are attorneys in the room. So Cecilia, put us at ease, please.
Absolutely. Thank you so much, Daniel, Caitlin, Katie, for having me. Thank you to the entire chamber members who are here to learn. I promise that this is going to be an easy program. And if you have any questions, I so look forward to your questions and your feedback and your input. So obviously we are in a time now. COVID has taken place. We've seen the rise of equity movements after George Floyd. And I think that we're all just in a space where we really want to protect our employees, our businesses. And so I do a two-part series. This first one is about how to protect your business and from employment discrimination lawsuits. The second one is about actually implementing diversity, equity, and inclusion efforts, which we'll see in June. But for today, I just want to teach you guys how an employment discrimination lawsuit comes into action and the ways that you can defend your company. And it's not, I try to tell people, first of all, I'm a plaintiff's attorney, so I sue companies, okay? And I try to tell people that it's not my goal to see companies go down, it's my goal to see companies and their employees really working as a team. And so I try to play basically the middle mediator, which is if the employees are happy, the businesses can grow. So I'm just going to take you into a PowerPoint and we can get right into this section. So. Here. Can everyone see my screen?
Yep.
Perfect. Okay, great. So decreasing business liability and employment discrimination lawsuits. The first thing you need to know is what are the authorities that govern employment discrimination lawsuits. So the first authority is going to be Title VII of the Civil Rights Act. Whatever, the second authority is going to be your state law, and then your own employee handbook, okay? Title VII is a federal law that protects employees based on race, color, national origin, sex, and religion. As you all, I'm sure, are familiar with, you cannot discriminate in any employment right based on those protected classes. State law, specifically the Kansas Act Against Discrimination, basically incorporates the foundation of Title VII into its own act. But I really try to work with companies to make sure that their employee handbook is solid. I think we all know as people in business that whatever you put out there is the best way that you can get caught up. So you are going to have to not only understand the language in your employee handbook, but you're going to have to really implement it in a way that is like to the highest integrity. I think a lot of times what we see is people get lawyers to write their employee handbook, and there's a miscommunication. Lawyers talk very differently than employees, at a coffee shop, right? So if your employee cannot understand their rights in your employee handbook, or if you can't understand your employee handbook because you just asked the lawyer to write it, you're gonna have some issues. So I want to go ahead and move on to what triggers employment discrimination, all right? So in order to present a legally viable claim of employment discrimination under Title VII and state law, a plaintiff must show that they suffered an adverse employment action based on one of those 7 protected classes. That's a mouthful. What does that mean? That means that the company maybe didn't hire someone because they were a woman, or maybe they didn't promote someone because they were because their skin is brown, or maybe they didn't promote someone because they have a handicap. An adverse employment action is any action that affects or alters the conditions of the workplace, and it typically involves discrete changes. So sometimes it's not as big as, oh, we're gonna fire Tammy because she's pregnant and we need more hours out of her and she can't meet that. Most of the time it looks like, you know what, Tammy, I think we're gonna have to limit your hours, right? We're gonna have to change your hours, which if Tammy is able to complete the task, then you're getting along the lines of a constructive termination. Maybe you're decreasing the hours so much that she has no choice but to quit because she has to find more money. So it's little discrete changes like that. And not only do you see discrimination, but what typically partners with a discrimination claim is a retaliation claim. So let's take Tammy in, for example. Maybe Tammy writes to HR and says, hey, I feel like you guys are limiting my hours because I'm pregnant. I'd like to report some discrimination. And then Tammy gets demoted completely. That is retaliation. And one thing I can say is that retaliation is one of my most successful lawsuits. Sometimes I don't even get the discrimination because perhaps there is a legitimate business reason as to why someone took an action. But the fact that my client perhaps reported discrimination and then an adverse employment action happened after that, man, I've won more lawsuits off retaliation than the initial discrimination claim. And so even maybe the manager doesn't demote Tammy. Maybe her coworkers are starting to be disrespectful, or her subordinates are starting to be disrespectful. That's called ratification. If she says, hey, now I'm being treated differently because I'm pregnant and because I made a claim of discrimination, and my subordinates aren't listening to me, and the company does nothing to rectify that, that can also be ratifying discriminative or retaliative behavior. So you have to be really careful about how you are engaging your employees, but more importantly, why you are engaging your employees in the way that you are. I want to talk about the business employee handbook. And again, this is very serious. This is where I see a lot of companies go down, okay? These are actual anti-harassment policies from companies that I've successfully sued, okay? So anti-harassment policy A says, it shall be the continuing policy of the parties that the provisions of the agreement shall be applicable to all employees without regard to race, color, sex, age, religion, creed, national origin, disability, or any other basis prohibited by the law. If your business employee handbook anti-harassment policy looks like this, please call me. Please call me. We are going to get you protected. This is such a broad anti-harassment policy that does not enforce any accountability to any employee supervisor that perhaps carries out some discrimination or retaliation. Not only is this broad, I'm gonna put it like this. If I take this into a courtroom and a company expects to defend, well, we do have an anti-harassment policy. It doesn't say what kind of actions are actionable. It doesn't say that a person can be punished. It's literally just language, and it's pretentious, right? Now, anti-harassment policy B. This is a policy that I can respect and that I actually enjoy as an attorney, okay? So I'm not gonna read the whole thing, but as you can see, what it's saying is that the business does not condone or excuse harassment of any kind. So first it sets a standard. We are not gonna condone or ratify this. Then it sets uh, what's the word? Maybe like a punishment, not a punishment, but really just an accountable standard for employees. Failure to observe this policy will result in appropriate disciplinary action. Okay, so the first thing you want to do in your employee handbook anti-harassment policy is say, we don't condone this, and then say, and it will result, if this happens, it will result in some type of action. Okay, so if you go down to the bullet points, it also gives examples of what kind of actions are harassment, right? We're looking at verbal conduct, such as epithets, derogatory jokes, comments, slurs, unwanted sexual advances. We're looking at nonverbal conduct, such as suggestive or insulting noises, leering, whistling, obscene gestures. Physical conduct, assault, unwanted touching, kissing, blocking normal movement. And then you go and you see threats and demands. And then there's also a little provision in there for retaliation. This is the type of anti-harassment policy that you want in your business. Why do you want this type of detailed policy in your business? Because if your employee is going to file a complaint of discrimination against you, this is what the Kansas Human Rights Commission is asking them. Do you have any written documentation of your allegations? Why do you feel the personnel action was discrimination? And are you aware of any statements made by any officials revealing bias against you? So I took these questions straight from the Kansas Human Rights Commission, basically the intake form that they use with people making complaints. You want your anti-harassment policy to be so detailed that an employee would have to meet your standard of what harassment is. Now, of course, there's a legal standard, but you get the first bite to define what it is, okay? Because this is what the Kansas Human Rights Commission is asking of them, all right? And I wanna show you guys this charge of discrimination. I wanna show you guys what your employee has to meet in order to file a charge that you may be liable for, all right? So as you can see, the EEOC requires that the business have at least 15 employees, and the Kansas Human Rights Commission requires that the business has at least 6 employees. So if you have a business and you only have 3 employees, this does not apply to you. And why is that? Because typically, if you have a business and you only have 3 employees, that's like a family-run business. And it's unlikely that there's discrimination in the family, right? Also, there are other laws that can account for any discrimination that does happen if it does. It's really important to look at the dates of discrimination. There's a statute of limitations for these types of actions. In the EEOC, you have 300 days to say, hey, you know what, something messed up happened to me and I want to report it. The Kansas Human Rights Commission, you have 180 days to report it. Now, that seems like a long time, but in the grand scheme of things happen all the time. And most times employees don't recognize when there was a discriminative act unless it's a really blatant one. And so with that being said, let's take Tammy again, pregnant Tammy, right? Tammy is in her 3rd trimester. She's just been trying to stick it out because she's about to have this baby. But now she's really feeling the heat. And even though she addressed it with the company and the company assured her they weren't discriminating against her, she says, you know what, it's day 299, I'm still going to file. You guys wanna make sure that you are on top of any time an employee says, I feel discriminated against. And if I were you, I would start running down that time frame, because you need to be clear on what could be coming down the pipe, okay? Now, those can also be used in a way to defend your business If someone files on day 301, if someone files on day 181, you can say, okay, you guys don't have jurisdiction. That's a way to defend your business. Now, what's really important is the left side of the screen. So failure to mark a box for a particular type of discrimination in the charge creates a presumption of not asserting claims represented by boxes not checked. There has been so much case law regarding whether or not someone can bring a claim for a box they did not check. So let's go back to Tammy, for example. Say Tammy was making a complaint for race discrimination, retaliation, and her pregnancy, which would fall under sex discrimination. But she failed to check the sex discrimination box. There is a presumption by the court that she is not claiming discrimination because of her pregnancy. However, that presumption can be rebutted if the charging party's factual allegations, where they would basically write what happened, is set forth and describes the facts supporting the additional basis being asserted. With that being said, you still have a viable defense that says, hey, all she did was say she felt this way during her pregnancy. She didn't say it was because of her pregnancy, which is also another huge way to defend your lawsuit should you come against one. Your adverse employment action has to take place based on one of those seven characters, not around, okay? So let's say Tammy was late to work every single day, okay? You can say, well, Tammy, we're demoting you because you're never to work on time. It has nothing to do with you being pregnant. It just so happened that the demotion took place while you were pregnant, but that was because we gave you 17 chances to start coming to work on time. So you have to be really mindful about what the person is making the complaint about and how they're using that language, which is why you get lawyers, right? But for today, I want you guys to make sure that you're catching it all, okay? And so how do you respond to a complaint of discrimination? And how do you protect your business? Well, first things first, you're gonna wanna get a signed statement from the aggrieved representing all of the facts are accurate and account for every complaint they have. You know, there have been a lot of cases that I've had where maybe the plaintiff comes to me after they've made their complaint and not before they've made their complaint. So what I'm working with is a layperson's complaint that doesn't know the legal bounds. If their complaint says, I feel like I got demoted because Cindy doesn't like me, I can't do nothing with that. I can't do anything with that. So as a business, you make sure that you get the first statement from the employee. Hope the employee doesn't know to get an attorney at first, okay? But you get the first statement and you make sure that it says, this is every account of discrimination or whatever that I feel, so that they don't try to pop things up on you later, because those can be held, a court and a jury can consider pattern and practice and to determine liability. The next thing you want to do is to complete a thorough investigation with a panel of leadership. A lot of the times that I have been successful in my lawsuits is because one supervisor or one HR person did the entire investigation. And it's really easy to say, hey, the same HR person that I made my complaint of discrimination to, who has a duty to the business, came up with a biased result in my investigation, okay? So you wanna get a panel of leadership. You wanna have the person from HR, maybe a supervisor from a different department, and a supervisor from the department that your employee works in. Why do we want to do this? So we can show that there is transparency and there is no bias. The supervisor from the other department has no reason to well, at least the argument is, they have no reason to have a bias investigation, okay? This investigation should include witness statements from everybody who was there. I have won cases because they did not get witness statements, and then I go and talk to the witnesses my plaintiff has told me about, and they give me the rundown. And I am able to say in court, Your Honor, these companies didn't even do a good investigation. They wouldn't know how they should have turned out. And that's why it was discriminative, because they didn't even carry out the investigation policy in their employee handbook. You want to document and do email review. Listen, especially in these COVID times, we know everything is through email. You better be the first person looking at the email and looking at, if someone was treated unfairly or poorly or discriminated against. The next thing you want to do is you want to take inventory. I think a lot of times businesses do not want to admit that perhaps they have hired a racist or a biased or a judgmental or a bigoted person. You need to look at how many complaints that supervisor, manager, or employee has received based on their attitude, based on the way that they promote, based on the way that they evaluate, based on the way that they hire. Sometimes it's not always just defending against employees. Sometimes it's taking the offense and saying, do I have someone in a supervisory or managerial position that is not fit to be here? That is a real, that's a real issue. Most people file employment discrimination complaints based on middle managers, not the CEO, not the CFO, based on middle managers. So you really have to take an inventory of the complaints that are had against the bad actor. The next thing is accountability. This kind of goes back into inventory. Hold the bad actor accountable. I don't care that you and Jerry have been friends for 20 years. Jerry's messing up your money. Okay, Jerry is putting your asset at risk. It is not worth you losing a business and providing income to families because Jerry wanted to be, unreasonable that day. Hold Jerry accountable. Do you have to fire Jerry? No, but that comes with its own liability. Okay, so you get to make the choice. The last thing you want to do is to mitigate the damage to the aggrieved. You guys, a lot of times your employees want and need their jobs. So they're not looking to quit. They just want a better employment scope. They just want a workplace that they can find peace. And here's another great way to defend against the lawsuit. We asked our employer what they wanted. They gave us a list that would make their working environment better, and we met these demands. Okay, now every now and then you will get the employee who's like, I want $20,000 to stay here. Make your choice, right? Most people will take 2,000, okay, just to mitigate the humiliation. But if it happens to go to court, what you can say is, during my investigation, I asked my employee what it would take to make their working environment better, and this is what they did, and this is how I met that. All right, and this is a huge, this is probably the most progressive way for you to defend against employment discrimination lawsuits. Keeping a diversity database is the most effective defense tactic. Why? You guys, if your business can show that in our hiring, we have a panel of diverse leadership that hires diverse talent. And I'm not saying, we only interviewed Black people or we only interviewed women. What I'm saying is, make it make sense. There's no way that the only people who qualify for the job is a white man. There's no way. Get a diverse panel of people to look at diverse resumes and bring them in, okay? And then keep record of that so you can show your work should you have to go to court. We have a panel of people who look at all types of resumes and then we bring them together, right? Also, you wanna measure your engagement and inclusiveness. Your business should have affinity groups, period. I don't care if you have 5 workers, they are different from each other. And there should be a support group or maybe even one group that just comes and says, hey, let's all do something inclusive together where we learn each other, okay? You also are gonna wanna keep a database about performance evaluation and rewards and promotions. You need to show, in case you have to go to court, how you're unbiased. right? Do that through data. It is a really effective way to do it. I think that a lot of companies don't know about that, probably have never even conceived it, and don't know how to get the data in one place. I can do that. Let me know after this if y'all need that. But that is the most effective defense tactic that you can use. So I am so grateful. I wanted to leave at least 20 minutes open for questions if you all have them. But the major keys that I want you to take away from this session is that you need an employee handbook with a wonderfully written, concise, but communicable anti-harassment policy. If you read your anti-harassment policy and you don't understand it, it's time to revise it. It's time to get someone in there who can revise it and make sure that your employees understand it as well. The next major key that should be taken from this time is you need to have a leadership panel review of complaints. If anyone comes to you for a complaint, the head of HR is not enough. They can lead the investigation, but they should not be the only person reviewing the complaint. Because if they are the person who receives the complaint and the only person who reviews the complaint and the only person who gets to make a decision on the complaint, I'm sorry, that's my favorite type of case because that's a winner. That's a winner, all right? Now, last but not least, retain a diversity database. Men lie, women lie, numbers don't, okay? If you can have a database that shows how your company is always moving toward diversity, it's going to be very hard for a plaintiff to say, they did this to me because I am in this protected class. Because if you can show numbers on how you guys make sure you're including everyone, I just don't know how a plaintiff can stand up to that, all right? So at this time, we definitely do have a lot of time left. I am so excited to hear any feedback that you guys have.
Thank you, Cecilia. Appreciate it. Very insightful. Would hate to be on the other side of the courtroom from you.
True.
We have a number of different businesses on the line, so I'm looking forward to their questions. I'm going to kick things off. And my question is specific to COVID. What are you seeing around, employers' ability to ask questions around vaccination and such, work from home? I think during this pandemic, I feel like, employees would just have to say, hey, I'm not feeling well. And then the employer then has to accommodate that employee, which I think is the right thing to do. But what are some legal backings that the employer has around COVID, vaccinations, and such?
Absolutely. So I'm thinking what immediately comes to mind, is a place like FedEx where the employee has to be in the distribution warehouse in order to do their job. When you're talking about COVID, what you're really looking at is health and disability discrimination, okay? And so the factors in health and disability discrimination are whether or not you can perform your job duty with a reasonable accommodation. You have to still be able to perform your job duty, okay? If you can't be in a warehouse, baby, you can't work here. And that's not discrimination. That is just, you can't perform your job duty. However, if you're in a business where you were able to shift the employment sphere to, working from home, it's going to be really hard for an employer to say they couldn't perform their job duty from home. Well, they've been doing it for a year now, right? An employer cannot compel an employee to do anything medically, but you can provide incentive, okay? You can provide incentive. You have to be really careful though, because if you say, hey, we're going to give a 2% raise to everyone who gets the vaccine, it can look like discrimination against those who are not getting the vaccine, okay? So you've got to be careful about the incentive and how you kind of word that, but you certainly cannot compel anyone to get the vaccine. The main thing is, if you cannot perform your job function, then it's not discrimination. Did I answer that for you? Okay, perfect.
Sorry, Cecilia, I muted you on accident. Can you unmute yourself?
No problem.
Okay. Any other questions from the floor?
I have a question. So say one of the great employers on this call has a fantastically written handbook, follows, option B, that or example B that you had demonstrated. What if they have all of this in writing, however, the actions don't follow what's in the handbook? How do you work through that?
So if I'm understanding your question correctly, what you're saying is they have a list of what looks like discrimination, but that particular, whatever happened isn't on the list. Okay. Really what you would do is you would, in your handbook, you would say, this is not an exhaustive list. We are able to determine what discrimination looks like based on circumstance, context, blah, blah, blah. There's a lot of times where, the courts have said, even though this isn't on your list, we could certainly, you don't have to put rape on the list for it to be sexual harassment, right? So you just say, this is not an exhaustive list, but it is so much better to have something that narrows down what the company views, because what you really want is to go into court and for a court to take you seriously and say, we actually believe you're trying to prevent discrimination or harassment because your policy is written so well, that it informs your employees. So basically, you just kind of put in there, this is not an exhaustive list, and every case will be looked at on a case-by-case basis.
Other questions from the floor? And I have a few more if you all don't have any.
That's why I love you, Daniel.
Well, I'll jump in. And I'm thinking a lot about our small businesses, and we have such a big percentage of our membership that have less than 10 employees, right? And maybe there's not an HR department per se, or the employee handbook isn't up to snuff, right? I mean, how do these businesses protect themselves against a claim, right? And if it ends up being expensive, I mean, I feel like that would be the type of claim that could not only cost you money, but your reputation. So how do these small businesses protect themselves?
Absolutely. So I'm really glad you asked that question, because I think, I am a small business owner, right? I don't have, 6 employees that I can have this claim come against me. However, it is so important for every business to have an employee handbook. I don't care if it's an employee hand sheet. Okay, you should have some policies. You run a business the same way that you do contracts in your business. This is a contract with your employees, and even if you don't have an HR department, you need to be prepared to follow some steps in case it comes along. Because say you have a business with only 10 employees, it takes one lawsuit to wipe you out. It takes one lawsuit, you guys, and I've seen it happen. In 2016, I sued a company. I sued a company for an employee that had only been there for 2 weeks. I took them for $500,000, and they literally told me that this is going to wipe out this is going to wipe out, and I'm like, listen, sorry it had to happen. You should have hired better middle management. And so it's just one of those things where it's like, you can't afford to not have an HR policy. You can't afford to have a poorly written employee handbook. It is literally your contract with your employee. And if I can go into court and show that you had a crappy contract, I can make it anything I want to be. Don't leave yourself open to an attorney like me. Don't do it.
Any other questions from the floor? Feel free to just unmute. Roger?
Yeah, Daniel and Cecilia, I just may have the question that say you've got a good employee handbook, but maybe it's circumvented from time to time. How much liability is that putting on a person that, everyone's okay with it for a period of time, but then, circumstances change and now someone suddenly offended by the same actions that had been taking place for some time?
Absolutely. That's such a great question, because that is one of the issues that pops up in these lawsuits all the time. This is what I'll say. There is a way for employers to show that the discrimination that took place was not actually offensive to the employee. How can they show that? They can show through witness statements that, hey, this type of behavior goes on around here. For instance, my mother is a truck driver, okay? She is a woman in a male-dominated field. And when I tell you, she gets down with the best of them. She has the mouth of a sailor. She is rough and tough, okay? If my mother goes into work one day and is out of nowhere offended that someone said something about her being a woman, there is a way for that employer to go get witness statements that says, hey, Bobby plays like this all the time. This is a joke, you know, and she's done this many times. Now, on the reverse side of that, if an employee can show, hey, even though this employer has this policy, they ratify behavior that is opposite to it all the time. So it's a really thin line, but it's one of those things where, are you willing to risk it? Are you willing to risk that someone may be able to convince a jury that this is not typical behavior, right? Because I'm just going to tell you, the facts in a lawsuit are important only to the extent that the jury believes them. So I know some really convincing plaintiffs, okay? They can get up and cry at the drop of a dime. I would never let anyone talk to me like that as a woman. I believe in feminine, blah, blah, whatever. And the whole time they could have been putting on an act. So what I would say is, if there's any behavior that is contradictory to your employee handbook, you either need to be ready to throw everyone under the bus and say everyone does this, or just change the culture. Or if you have that type of behavior, with some people say it's joking, don't do it at work. You know, do it at the bar, or do it when you guys meet outside of work, so that it's not a work-related thing. That's what I say.
Thank you. Appreciate that.
Absolutely.
Any other questions from the floor? Feel free to unmute yourself. Okay, I have a question, and this is around social media, Cecilia. I mean, as employers, you know, our small businesses, I mean, everyone has employees, and folks have the ability to post whatever they want on their social media. What can businesses not do to control that?
What can businesses do to control individual employees on social media? Make a policy. One thing that you have to understand about your employee handbook is that it is a contract with your employee. If in your employee handbook you say, hey, you know, we do not support, ratify, or allow derogative language, or you know, sexual content, or bias, or, you know, bigoted, you can make a policy around that, and that employee has the wherewithal and the right to say, I want to sign this contract. And so if they go outside of that, then you have the right to carry out whatever action you want to. What I will say is, what I've seen a lot of companies do is, you can post whatever you want on your social media as long as my company name is not on your page. So we know on LinkedIn, on Facebook, you can say, I work for this company. Well, if you want to go against the employee handbook, or if you know, just have to post whatever, tell your employees that they can't represent that they work for you, which is a broader issue, right? You want employees who are moving your business vision forward. So I would go with approach A, which is write a policy that says, you know, we don't do this. Because what happens? We've seen this in the news, you guys. You got Joe Black who said something in support of something, you know, racist or sexist. They take the whole company down that he works for. You need to be able to show, we don't stand for this, that person is gone. And not only don't we stand for this, look at our policy. See, I promise we don't, right? You wanna protect yourself. So make sure that employee handbook is solid.
Thank you. Yeah, that's great insight. Any other questions from the floor? We've got about 15 minutes.
I really expected a lot more questions.
That's
But
okay.
I think people get nervous because if you really do have a business question, you guys, we're here to learn. There are so many businesses going down because people were scared to ask the question, and no question is dumb. This is where you learn. And I would rather you learn it from like a friendly plaintiff's attorney than from someone across the room, you know?
Well, if I'm hearing you right, obviously the employee handbook is critical.
Absolutely.
I think, as this workforce continues to evolve and society is becoming more and more diverse, so are workplaces, what can employers do? And I think I know the answer, to just be prepared, to be able to absorb or mitigate any type of potential filing. So I think, none of us want that.
Absolutely. I think, and this is in my next presentation, that is really just talking about diversity, equity, and inclusion, and really implementing a DEI program in your business. I think just human nature is that we like what we like and we don't want to change it, right? So say your business has been operating well with what you've got going on. The world is constantly changing, it's constantly evolving, and we all seen how quickly that happened after COVID and after George Floyd. You can't afford for your business to be stagnant. There needs to be some type of program in place or some type of consultant that you bring in to make sure that you are moving along with the times, that you are being inclusive. Because at the end of the day, it's not just about the money you make, it's about the talent that you retain, okay? More and more we are seeing women in the workforce, right? Operating at these very high levels. We are seeing people of color in the workforce, brilliance, right? You want to retain that talent. You can't afford to lose it. Even if it's just from a business income standard, you can't afford to lose your best talent. So you've got to learn and you've got to seek out opportunities or get a consultant who can continue to send your business in the right direction. Because it's not, Daniel, I honestly don't think that there are racist businesses. Now, some of them are built off of racism and the inequities. But what I think is that we hire people that we don't know, right? And we don't know that they're discriminative or that they're bigoted or that they're biased. And so while my company has a policy, I'm not doing any checks to see how my employees are being treated by middle management or supervisors, right? And so it's like, if you don't have a program that is made for these type of checks, you're going to face a discrimination lawsuit. And it's not enough to have an HR department. HR department does everything. They do money, they do sick leave. You need something that is going to focus on diversity, equity, and inclusion. Even if it's just you call someone in every 6 months to do a review, right? I think that's how you stay up to date and you stay moving with the time and with the culture.
Thank you. Great. Okay, last chance for final question. Okay, looks like we'll give you some time back. We did record the session, Cece, so we will be posting this online, and you see Cecilia's information on there. Feel free to contact her. She is a chamber member and will be at different events. I do want to plug a business after hours that we're hosting later on this month. We'll be at the new Legends Field, home of the Kansas City Monarchs. We will be out there May 27th. Cecilia, I hope you will join us, as well as all of you on the call. So thanks again for joining us today, and thank you for participating.
Thank you so much for having me.
Thank you. Appreciate it.